everybody to the Selden Society Australian Chapter lecture on the Supreme Court Fire of 1968. Chief Justice, judicial colleagues and distinguished guests all, I also welcome those who are virtually present in the courthouses in Townsville and Rockhampton. I also welcome Mr Joshua Tate, who's the Selden Society US Treasurer here tonight. And of course a particular welcome to our distinguished speaker, the Honourable Richard Chesterman, AO RFD QC. Richard graduated with a Bachelor of Arts in 1965 and a Bachelor of Laws in 1968 from the University of Queensland. He served as the Associate to the Honourable Justice Wanstall from 1966 to 1968. He came to the bar in 1968 but commenced practice in 1970, taking silk fairly shortly thereafterwards in 1983. He was appointed a Judge of the Supreme Court in 1998 and, if I may say so, to my own particular pleasure, was appointed a Judge of Appeal on 11 December 2008. Justice Chesterman was appointed an Officer of the Order of Australia in 2011. To our disappointment, he left us, that is to say, he left judicial office in 2012, and you will have read that since then he has heard an inquiry for the Queensland Crime and Misconduct Commission. Today it's of particular relevance that at the time of the Supreme Court fire, Richard was a final year law student and associate to then Justice Wanstall. He is therefore able to bring his personal reminiscences to this lecture. Could you please welcome our speaker?
Thank you. At 10 to 4 on the morning of Sunday, 1 September 1968, the night clerk in Lennon's Hotel was told something by a man who dashed into the lobby. The clerk went outside to see for himself. Looking across George Street, he saw smoke and the reflection of flames in the upper windows of the Supreme Court. A minute later, 4 fire trucks from the Kemp Place depot were on their way, First Officer Christian in charge. He took 2 engines into the courtyard and sent 2 into Ann Street. The Ann and George Street wings of the building were burning fiercely. Christian went to the front doors, which were a thick glass set in a timber frame. Through the glass, he saw a night watchman approaching from the end of the corridor. Expecting the doors to be locked, he waited to be let in. In fact, the doors were unlocked. Showing commendable courage, Christian set out to determine the limits of the fire. Finding his way by torchlight, he climbed the stairs to the first floor gallery and turned towards the criminal court. He was stopped by an intense fire. Flames were going out through the roof. Let me show you what he did. So that's George Street. This is the front door. Can you hear me? That's the corridor, and this is the central hall. The stairs are here, going up to a landing halfway up, and then the first floor, where there were corridors going to the criminal court, to a civil court, and along here. Christian returned to his men and repositioned the fire engines in Ann Street. He was concerned to stop the fire spreading to the Adelaide Street wing, so he re-entered the building to more precisely locate the fire. This time he kept the ground floor, turning right from the central hall along the judge's corridor to the staircase used to access the criminal court, which at the time was ablaze. So that's the corridor. There are stairs about here going up to a room behind the criminal court. He climbed the stairs and heard the sounds of conflagration in the courtroom. Having ascertained that the fire was confined to the upper levels of the building, he left the direct operations and moved some of his men. There was a disused chimney at the end of the building nearest Ann Street. Its timber supports had been burnt, and it appeared to the first officer dangerous to have men anywhere near it. A little later, it collapsed. There was a second fire that morning. A little before 4 a.m, the driver of a taxi going along North Quay, near the court, noticed a glow coming from the O'Connor boathouse. He radioed his base and fire brigades were called, arriving at 4:01. That fire was quickly extinguished. The other took longer, but by about 6 it too was out, though parts of the court still smoked and smouldered. Before going further, we should look at the building to see what was lost. That's looking really across from George Street, where the Lennon's Hotel was built later. That, of course, is looking across the river from West End. Now, that is not as the building was in 1968. That photograph must have been taken a couple of years earlier. I've included it to show that that's the excavation for what became the District Court building. In 1968, that building was well advanced, and the concrete skeleton went at least as high as the old court. My point is that the access to these verandas, top and bottom, had been sealed off during the construction so that the doors and windows were sealed. I've taken the following description of the court from John McKenna's Concise History of the Court. The building was opened in 1879. It had been designed by Mr. F D G Stanley as a, quote, T-shaped building with 3 arcaded wings radiating from a central tower. The design was intended to maximise natural light and ventilation in the days before electric lighting and air conditioning. The original concept called for a stone building, but for reasons of economy, it was constructed of concrete rendered over common bricks. To quote, the gabled tower contained the building's internal focal point, the Judge's Hall, with a ceiling 17 metres above ground level and a principal staircase giving access to the upper levels of the building. Corridors radiated from the central hall to each of the 3 wings. So, that wing towards Ann Street was occupied by 4 sets of judges' chambers. That wing, the registry, registrar's offices and the Chief Justice's chambers. On the floor above, a jury room and the criminal court. There, the bar robing room and the large civil court, which was used by the full court and the High Court when it was in Brisbane. Looking at that, there was a courtroom there, and behind that a library. If I go back to the plan, the library was there. That was the court nearest George Street, and there were various rooms there. Note, there and there were staircases which gave access to the public to get to the public gallery that overlooked the 3 courtrooms on the first floor. That staircase there had been boarded up because of the construction work. As I mentioned, the corridor running from the Judge's Hall towards the Ann Street end contained 4 sets of judges' chambers. At the end of the corridor was the staircase which Kristen had climbed. It gave access to an anteroom behind the bench in the criminal court. At the time of the fire, the 4 chambers in that wing were occupied by Justices Hanger, W.B. Campbell, Stable, and at the end, under the criminal court, Justice Wanstall. The associates' rooms adjoined their judges' rooms. Mine was at the end of the corridor. It was very spacious, with views onto Ann Street and over North Quay to the river. There were 2 other sets of judges' chambers in the ground floor of the George Street wing. Justices J.A. Douglas and Sheehy had their rooms there. There were several people in the court building on the night 31 August, 1 September. Bert Cowell was a watchman employed by the Department of Works. He was responsible for the safety of the Supreme Court from 7 a.m. to 8 p.m. on the Saturday. He was relieved at 8 by Norman Tesh, known to us all as Monty. The only thing to note about Cowell's presence is that he took his lunch to work in a plastic box, which he left in a refrigerator in a room near the registry. In the box was a small fruit knife. When he dutifully reported for work on the Sunday morning, he noticed that his lunch had been taken out but left on top of the box. The knife was missing. Monty was portly. He had an artificial leg and walked with difficulty. He was agreeable and cheerful, but somnolent. He was usually asleep by 10 or 11, sometimes in the watchman's room and sometimes on a judge's sofa. Monty's duties included making an inspection of the adjacent magistrates' court every 2 hours at 10, 12 and 2 a.m. Unusually, Monty would lock the front door when he was in the building, but leave it unlocked when he left to patrol the other courts. He said he'd been instructed by departmental superiors to do this. His patrol took between half an hour and 3/4 of an hour, but no longer. Also in the building was Angus Innes, Associate of Justice Campbell, and finally a law student. He, as did the other associates who were students, used his office in the judge's library for study. Angus was at the court all day from 10 on the Saturday morning. He was joined after lunch by Charles Brabazon, later Judge Brabazon QC, who in 1968 was a clerk employed in Crown Law to assist the Chief Crown Prosecutor. Charles left the building about 5 and did not return. Angus left about 6 to have dinner, but returned about 8 to resume study. Charles was probably the last lawful entrant in the criminal court. He went by way of the judge's staircase in search of a textbook at about 4:30. The courtroom showed no signs of anyone having entered it since the previous Friday afternoon. Ian Hanger, now Ian Hanger AM QC, was associate to his father and finally a law student. He was studying in his room with a friend whose name no one now remembers. They left about 10 o'clock when a woman, whom Monty thought was Mrs. Hanger, Ian's mother, drove to the court and took them away. I suspect it's a case of mistaken identity. I'm confident the driver was a younger woman. Angus left the building shortly after 1 on the Sunday morning. He turned off the lights in the judge's corridor and looked for Monty to tell him he was leaving, but couldn't find him. Angus had to unlock the front door to let himself out. He had no means of locking the door from the outside. In 1968, David Bertram Brooks was a 30-year-old shiftless alcoholic. He had some drinking friends, but no fixed abode and no regular employment. He had been arrested 18 times for public drunkenness, but had no criminal convictions. Constable Rockley of the City Police Station found him fast asleep, sitting on a pedestal in the public toilets in George Street, opposite the Transcontinental Hotel at just a bit after 3 a.m. Rockley woke him and took him outside. Brooks said that he had been at the Night Owl Cafe and just came down here and went to sleep. He had been drinking for hours before he went to the cafe. He claimed that he lived with his mother in a caravan at Holland Park. Constable Rockley told him to go there and watched him walk off along George Street, going towards the city. He thought Brooks was steady on his feet and was quite sober and capable of making his own way home. A serious fire in the Supreme Court was obviously an occurrence of some moment. The police must have been notified of the event almost as soon as the fire brigade. An officer rang the Chief Justice, Sir William Mack, and he in turn rang some, but not all, of the other judges. He certainly contacted Justice Campbell and probably Justices Douglas and Hanger. Francis Douglas, who was then his father's associate, recalls him receiving early notice. They went immediately to the court. Justice Campbell called Angus and they too rushed to the court. It was then obvious that the worst affected part was the end of the Ann Street wing under the criminal court occupied by Justice Wanstall. Justice Campbell ascertained that he had not been told of the fire. He instructed Angus to ring me. I found my judge and his wife at church on the Sunday morning. I broke the news and drove quickly to the court, where I parked in the courtyard, which was empty, save for a fire truck. Photograph which I think you've all seen before. The car on the right is mine, the fire truck belongs to others. If you look behind the damaged George Street wing of the court, you can see a concrete structure. That's part of the District Court building, which is then under construction. You can see the damage to the roof of the tower to the left. I went in through the front doors, saw no one, and walked to the central hall. The floor was covered by burnt timber beams, broken bricks, and sheets of roofing iron. Note, that's part of the gallery. It ran around the four walls of the hall, but you can see there that that part's collapsed. That's looking out towards North Quay. I entered the judge's corridor and I saw that it was partly blocked. At the far end, the door to my room was completely blocked by fallen debris, some of which was still burning. I thought it might be possible to get into Wanstall's chambers, but as I went cautiously forward, some more burning debris fell into the corridor ahead of me. I retreated and went out into the lawn adjacent to North Quay, where I saw the Chief Justice, Justice Campbell, and some others. I stood on the outskirts of the group. As we were standing there, a sheet of corrugated iron fell from the roof, swaying as it dropped, and landed heavily nearby. The senior fire officer asked us to move further away, which we quickly did. He then had a fire hose play on the remaining iron and masonry at the top of the tower to dislodge any remaining loose material. Francis Douglas had the recollection that his father and Justice Campbell tried to inspect the latter's chambers by way of the judge's hall and the corridor. There were firemen present in the building, but they allowed the two judges to go in. Not long after they emerged from the corridor and crossed the hall to go outside, the gallery, which I pointed out before, collapsed. Of the 4 sets of chambers in the wing, only Justice Wanstall's were destroyed. The fire had been fiercest in the criminal court above. The burning dock, bar table, witness box, and the associate's bench had fallen into his room and partly into mine. This was obvious when Justice Wanstall arrived with Mrs. Wanstall. When she learned that the Chief Justice had neglected to inform them of the fire, she was visibly angry. The Chief Justice left soon after. So there is George Healy, the Chief of the Fire Brigade, Sir William Mack, and that's David Longland, who was then Under Secretary of the Department of Works. That is Angus Innes. That is Justice Campbell. That handsome man stepping carefully over the fire hose is me. Wallace Campbell, Mrs. Wanstall, Justice Wanstall, and we cannot identify the other two people in the photograph. You can see the damage. You can see the tower's been cleared of loose material. The roof, of course, is gone. That was the criminal court. That was my room, and those windows were into Justice Wanstall's chambers. Brooks had not gone straight home. He walked along George Street until he came to the Supreme Court, which, it seems, he looked at resentfully. Brooks approached the front doors. They were unlocked, so he went in. The corridor behind was lit but deserted. That's that one. The night watchman's room was right about there. The bailiff's office was right about there. There are the stairs, of course. That's the central hall. That's the registry wing. That's the judge's corridor. And the staircase to the civil court was round about there. They're the Chief Justice's chambers. He walked into the hall and then left along the registry wing, where he found the alcove at the base of the staircase to the civil court above. He also found the refrigerator where Bert Cowell kept his lunch and took the knife from the box. He climbed the stairs and entered the court, through which he walked, picking up a Bible on the way. He left the court from the public entrance at the back, walking into the corridor leading to the gallery around the central hall, and then into the corridor leading to the criminal court. So, this is the upper level. There's the civil court. He came from here, walked through that corridor, around the gallery, one way or the other, along that corridor to the criminal court. He went in and he gathered some typing paper from the court reporter's desk and went back along the corridor to where there was a cupboard in which the cleaners stored their equipment. It was near the disused stairwell I pointed out before, and was where First Officer Christian noticed the fight had been most ferocious. Brooks put the typing paper in the cupboard, lit a match and put it to the paper. He returned to the civil court where he noticed the pens and inkwells on the associate's desk. That's the old courtroom. There's the associate's desk, there's the bench. The staircase ended about there. I don't know when that photograph was taken in relation to the fire, but that's how the court looked at the time. He left the courtroom as he had come by the judge's stairs and retraced his steps to the front door. He went around to the back, climbed over the fence to North Quay and walked towards Grey Street Bridge. On his way, he passed O'Connor's boathouse, where most of Brisbane's youth learnt to dance on Saturday mornings in the 1950s and 1960s. He climbed a drain pipe to the veranda of the upper level, broke in and set a fire in the kitchen. He then continued to walk along North Quay until he came to the Christian Science Church near Upper Roma Street. He sat on the porch which was lit and read the Bible which he'd stolen from the court. He left it there, walked across Grey Street Bridge to South Brisbane where he hailed a taxi to take him to his parents' caravan at Holland Park. By this time the court was visibly ablaze and he asked the taxi driver to detour past so he could get a good look at his handiwork. To return the account to the Sunday morning, the fire trucks left except for a watching crew. Most of the judges went home. People came and went. One of those who came was Ken Mackenzie, then a Crown prosecutor, later Mr Justice Mackenzie, who got access to the site by attaching himself to the Attorney General's private secretary who was making an inspection of the damage. Ken was an accomplished photographer and the photos he took that morning have become iconic. The one of the fire brigade in my car is one of Ken's, and the second photograph of the people outside was also one of Ken's, as are these three. Note the portraits. They now hang outside. That's Lily, that's Griffith. They get a mention later on. That, of course, is the central hall. That's the gallery on one side. The library was through there. You see them better on the side screen than here. The colour is washed out, but they, as you can see, they're very good photographs. And there's a fireman playing a hose on some burning debris in the hall. That's the corridor to the criminal court. That's where the gallery fell not long after Justices Douglas and Campbell came out. There was altogether a general air of bemusement. Suddenly news spread rapidly that something of significance had been found in the civil court. A number of people climbed the judge's staircase to what had just become a crime scene. No one stopped us. My recollection is that both firemen and policemen were present. On the associate's desk, we saw a large sheet of framed blotting paper over which some ink had been spilt and on which had been printed using a steel-nibbed dip pen, "Judge not, lest you be judged, sinner." The blotting pad had been skewered to the desk by Bert Cowell's knife. A few burnt matches lay on the floor. It was at once obvious that the fire was arson. The Supreme Court had been deliberately set alight. Brooks had written the message as he walked through number 1 court, the civil court, on his way out of the building. The matches were not another attempt to start a fire. He lit them so he could see to write. Monday was a day of chaos and farce. The Supreme Court's 4 principal courtrooms, including its only criminal court, were unusable. Now that is Justice Wanstall's room, what was left of it. That's a photograph, I'm sure, taken from the top of the partly built district court where I showed you the site, looking, of course, to the old Victoria Bridge. Note the clean top to the tower. That was the wing leading to the criminal court. That was the criminal court. That was the top of the disused stairwell. And this was the beginning of the George Street wing. That's looking towards the river, of course, over North Quay. That's where the criminal court was. The only parts of the building untouched by the fire and capable of occupation were the registry, the registrar's offices, and the Chief Justice's chambers. No one seemed to know what to do. People milled around aimlessly. The situation called for firm, sensible leadership from someone in authority. It did not come from the Chief Justice. He took over the chamber list and sat, as was then the norm, in his own chambers to hear applications. It gave an appearance of business as usual, but things were not usual, and he should have been supporting the efforts to remove the judge's property which had been damaged or was in danger of being damaged. No one took control of the situation. The Department of Works has sent a number of its labourers to court early on the Monday morning with equipment for carrying books. Apart from the Chief Justice, all the judges whose chambers were in the main building wished to have their libraries and possessions removed and taken to a place of safety as quickly as possible. The need was particularly pressing for the 4 judges whose chambers were in the worst affected wing. Access to those rooms was possible, but difficult. There was still some residual danger of falling debris. The only way of getting into Justice Wanstall's chambers was through a window, the sill of which was about 5 feet above the ground. The associates looked around to see how the judges' books could be got out. We pressed the Works Department employees into service. We arranged them in gangs to come with us into the building to begin the task of removing books. They were quite willing, as they might be, having been supplied with hard hats. We'd not been engaged long in the task when word came from a supervisor that the site was considered dangerous and the workmen had to get out. Annoyed but undaunted, the associates remained behind and passed books out to the workmen. We asked if we could wear their hats for protection. They agreed and we put them on. Working in this way was obviously slow and inefficient, but we did what we could. We suffered another setback when the same supervisor informed us that the hats had been issued to his men and they had to wear them, even though they were outside. We therefore had to give back the protection and work on bareheaded. Ian Hager remembers that when we were taking books from his father's chambers, he got a phone call from David Longland, the Under-Secretary of the Department of Works, who ordered us to get out of the building. He may have been concerned for our safety or his liability if someone were hurt. Ian told him that we wouldn't need to be in the building if his workmen weren't timid and inept, or words to that effect. Longland made a formal complaint to the Chief Justice about our disrespect. The judge's response was to pass a resolution thanking the associates for their efforts. In the process of trying to organise the workmen and to arrange for the carriage and transport of the books, a degree of foot traffic passed by the Chief Justice's chambers. Irritated by the noise and the motion, he issued a command that if the activity didn't cease, he would have the actors committed for contempt. The Works Department men went back to the depot. The slow progress of removing books ceased altogether. The situation was saved by the fire brigade, a firm of insurance loss assessors, and particularly by a small band of friends. The fire officers were well-led, disciplined and efficient men. They removed the rubble blocking entrance to the rooms from which books had to be taken and ascertained that there was no immediate likelihood of anything falling from the upper floor. They brought and left at the site 2 portable floodlights. The loss assessors represented the insurers who had covered the judge's property. They arranged for a number of trucks and labourers to carry the books to an unused warehouse at the end of Upper Roma Street, about where police headquarters is now. The real difficulty remains in physically removing books and other effects from the building to where the workmen could place them in boxes and carry them to the trucks. This was not a proper task for the fire officers. The public works personnel would not do it. The contractors had been engaged by the insurer only to carry the books from the outside of the court to the warehouse. The only other available workforce consisted of the associates, Angus Ennis, Ian Hanger, and me. Justice Stable's associate was an elderly man who could not sensibly have been asked to assist. Elizabeth Nosworthy, at the time, was associate to Justice Matthews, who had chambers in the adjoining complex. She came over when court adjourned and joined us in the work. There was no point in removing anything from Justice Wanstall's chambers apart from his books. Everything else had been destroyed. The other judges were more fortunate. Their rooms had not been touched by the fire, but had suffered smoke and water damage. Those rooms had to be emptied of robes, personal effects, personal papers, official papers, and personal items as well as books. If the contents of each room had to be emptied by one associate only, the task would have been immense. I was helped to remove books from Justice Wanstall's room by 2 bailiffs and by my father. The work started mid-afternoon and continued into the night. We used the floodlights, one set up on the lawn and the other positioned so that it shone into the building. My father and the bailiffs left when the books had been taken from Justice Wanstall's room. I stayed to help the others. Late in the evening, Justice Campbell arrived with pizzas and cold beer. In the days following the fire, the Supreme Court Library collection was removed by Public Works personnel. These books were also taken to an empty warehouse in the same location. As far as I recall, none of the books had been burnt, but many were damaged by smoke and/or water. They were removed in haste and laid out to dry on trestle tables in random order. Members of the bar, as well as law students from the University of Queensland, gave their time to sort the books into their proper series and sequence. Now that, I'm sure, is close to the camera is Paul Finn, later Professor Finn and Justice Finn of the Federal Court. I don't recognise the woman. She would, I assume, have been a student at the university. But that's how the books were laid out to dry. 6 judges were dispossessed as a result of the fire. One of them, Justice Hanger, was president of the Industrial Court, and he'd removed his library and effects to his chambers attached to that court where he sat. The building at 370 George Street, near the corner with Turbot Street, had just been built. The government leased 2 floors and fitted out 2 sets of chambers on each floor. Justices Wanstall, Stable, Douglas and Campbell went there and conducted trials from their chambers. As related earlier, Brooks caught a taxi to his parents' caravan. Contrary to what he told Constable Rockley, Brooks did not live there. His parents had not seen him for weeks. Despite the hour, his mother gave him some food and put him to bed. His father was less sympathetic. He was a stern Presbyterian who disapproved of his son's slothful life and constant inebriation. Brooks slept until about 10 when he left. At 5:30 on Wednesday morning, 4 September, Brooks visited a sister, Mrs. Kimber. He was very drunk. He asked his sister if she'd read the papers. Mrs. Kimber had no time to read newspapers and said so. Brooks said to her, "The courthouse fire, I lit it." Mrs. Kimber did not believe him. She said, "David, you're drunk." Brooks' next reply was odd. He said, I didn't do it. Gilbert did it. He was alongside me and he lit it up." Gilbert was their brother who'd been burnt to death exactly 6 years earlier. Brooks was with him when he died. Later that morning, Mrs. Kimber drove Brooks to the valley where he planned to meet some friends, and she thought, continue drinking. Her suspicion was right. Brooks was arrested for public drunkenness that afternoon. He was a rancorous drunk who struggled against being put into a cell. "I got square with you blokes," he said. "I burnt the Supreme Court down, and I'll burn this effing joint down." The watchhouse keeper, Senior Sergeant Chippendall, was sceptical. Brooks was drunk, dishevelled, dirty, and looked unwell. So his statement, though repeated, was not taken seriously. However, the officers investigating the arson were informed. Detective Sergeant Marnie went to the watchhouse at 7:15 p.m. He spoke to Brooks, who was impatient to confess. He said, "I wish you fellows would believe me. I've been telling everyone, and no one will believe me. I set fire to the court all right." He was given the usual warning, but he wouldn't stop. "Yes, I know, but I know I lit the fire. It's a very serious matter, and I want to tell you the truth about it. I've always believed in the truth." Marnie was still doubtful and said that he wanted to be quite satisfied that Brooks was the person responsible for the fire. To help dispel his doubts, Brooks said, "Well, you know about the blotting pad and what I printed on it." Marnie said he had seen a blotting pad with a certain scripture, and Brooks again volunteered, "I printed, 'Judge not, lest you be judged, sinner.'" He explained that he knew about the Bible. To provide further proof of his guilt, he asked, "Did you see the knife that I stuck in the middle of the blotter?" Marnie said he'd seen it. Brooks went on, "It's my work, I done it. Give me a bit of paper and I'll show you what I did." Marnie now seems to have begun to believe that Brooks may indeed have been the arsonist. So he gave another caution, which Brooks also disregarded. He's given some pieces of ruled foolscap and a biro, and he printed several times the words he'd left on the blotter. Brooks then gave a detailed account of his movements, starting with being chased out of the toilets in Roma Street. His account of the fire itself was that, "I put this typing paper in the cupboard, lit a match, and set the paper alight in the cupboard, and away she went. I put some more paper on the flames, and I noticed in the light from the fire that there were some newspapers inside the cupboard. She didn't take long to get a go on. I threw some more paper in the fire, and I made sure it was going properly, and I went back to the court I first went into, and I struck some matches, and I saw the wooden pen and inkwell, and I printed words from the Bible onto the blotting pad in the middle of the table." Even after that statement, Brooks doubted that he would be taken for a serious criminal. He said to Marnie, "You still don't believe it was me, do you?" Marnie asked him to go on what's now called a walk-through. Brooks agreed. In the ruined central hall, he said, with evident pride, "She's a mess, isn't she?" He showed them the fridge from which he'd taken the knife, the associate's bench where he'd written on the blotter, and indicated the stairs he'd used. He pointed to where he got the paper and the cupboard where he had started the blaze. He led them from the court along North Quay, past O'Connor's boathouse, to the Christian Science building and to the porch where he'd left the Bible. The group then went to the Criminal Investigation Branch where the questioning continued, after further cautions. Brooks was asked to print the words he'd left in the court on blotting paper using a steel nib pen to reveal what resemblance there might be between that document and the blotter in the court. Biro and foolscap was thought to be too dissimilar a medium for comparison. Brooks agreed readily and even noted that the pen he'd been given by the police was a new one, whereas the one in the court was old. The police had located the taxi driver who took Brooks to his parents' caravan, and he was asked if he was prepared to be identified in a lineup. He declined the offer, saying, "No, he will know me." The meeting was arranged, the taxi driver was brought in, and Brooks all but accused him of neglecting his duty as a citizen by not reporting him to the police when he must have suspected that he, Brooks, had started the fire. Brooks said, "I was waiting for them to pick me up. Nobody came, so I gave myself up." Marnie was still being cautious. He asked whether Brooks had deliberately set fire to the Supreme Court on 1 September 1968. The reply was, "Yes, you must be convinced by now. I did it on my own. I went there on my own, no one else." He was asked why, and he explained, "I'm a sinner and I'm sour on the world. I've got to be punished. I wanted to do something big and wrong, and after getting chased out of the toilet, I saw the Supreme Court and I decided it was a big enough place to burn down. I went inside and you know what I did." To leave no shadow of doubt as to his guilt, he then wrote out a confession in his own hand. During his interview, Brooks had told the investigators that he had been at his sister's house earlier that morning and had told her that he'd started the fire. Mrs. Kimber was brought to the CI branch at about 11 p.m, where she saw her brother. She was, of course, upset for him and said, "David, you couldn't have done it." He replied, I did. I've been here for hours telling everyone, but they won't believe me." He was right. The police remained sceptical that the Supreme Court, an institution of state power, symbol of authority, could have been casually destroyed by one of life's obvious zeros, an idle, disgruntled drunk, sour on the world, whose account was that he stumbled through the front doors, rambled unremarked through the building, unhurriedly collected kindling material, and wantonly put a match to the edifice of justice. Admissions to Detective Sergeant second class were deemed insufficient. It was thought that the confessions would have more authenticity if made to someone of greater distinction. A detective inspector was found in the person of Donald Buchanan. Marnie briefed him on what had happened, and Inspector Buchanan renewed the questioning. He asked Brooks if his admissions to Marnie were correct. Buchanan was apparently concerned that Brooks may have learnt sufficient details of the arson from newspaper reports to give an air of verisimilitude to his confessions. He told Brooks so. The response was, "Yes, I burnt it. How would I know about the words printed on the blotting paper and about the knife if I didn't do it? Yes, I saw it in the paper and I printed more for the detective. The handwriting people should know that I wrote the one in the court, and what's more, I'll swear in the Bible that I did it. Buchanan asked if anyone had given Brooks the information which he had used in his submissions. He denied the possibility. Look, he said, I did it. What have I got to do to convince you blokes? He had in fact done enough. He was arrested. The charge was that on the 1st day of September 1968 at Brisbane in the state of Queensland, you wilfully and unlawfully set fire to a building, namely the Supreme Court. Surprisingly, in view of his ardent desire to be caught and his acknowledgement that he should be punished, he pleaded not guilty. The trial was heard before Mr Justice Hoare and a jury over 3 days, commencing 25 November 1968. Justice Hoare was, of course, one of the judges unaffected personally by the fire. Jim Gibney, later Judge Gibney, prosecuted, and Alan Demack, later Mr Justice Demack, defended. Despite old Mr Brooks' disapproval of his son, he retained a fatherly concern for him. He approached his solicitors Robertson Kane to inquire about representation. Miles Kane kindly directed him to the public defender. The charge was limited to setting fire to the court, so the arson of O'Connor's boathouse was largely irrelevant. Evidence of it was led, however, to negate the defence of accident or lack of intent. A drunk might stumble into one building and inadvertently set it alight, but 2 fires started by the same man, minutes apart, in buildings separated only by about 200 metres, could not sensibly be regarded as accidental. For that reason, Brooks' admissions of having burnt down the boathouse were put to the jury. His motive for the second fire was that some years earlier he had gotten into a blue with a mug during a dance there, had been thrown out and told never to come back. Brooks was unable to give coherent instructions. Given that fact and the plethora of confessions, all the defence could do was put the Crown to proof. There were two possibilities for raising doubt. Brooks' drunkenness may have affected the formation of the deliberation necessary to prove arson and may also have affected the reliability of his admissions. He was certainly very drunk when arrested in the afternoon of 4 September. At the time of the police interviews, he was tired, unwell, and had not eaten. The defence argued that his incriminating answers might have been the result of confusion and exhaustion. The prosecution was very thorough, although Jim Gibney was always scrupulously fair. He called the Assistant Under Secretary of the Department of Works to prove that the Supreme Court was built on a Crown Reserve set aside for departmental and official purposes. He was asked whether he'd given permission for anyone to set fire to the Supreme Court. and he replied emphatically that he had not. The defence said probably it's only fun of the trial. The Secretary was asked, what authority would you have to give permission to set fire to the Supreme Court? He answered lamely, as far as I know, I wouldn't have any. Evidence was led of the numerous submissions made to the Watch House Senior Sergeant, the Detective Sergeant and the Detective Inspector. Brooks' movements on the early hours of 1 September were proved by the constable who evicted him from the toilets and by his family, the taxi driver and the caretaker of the Christian Science building who found the Bible. A fire investigating officer testified that the fire started with Brooks that he had said he lit it and that an adjacent disused stairwell had provided the ventilation for the fire to take hold quickly and to burn furiously. A handwriting expert opined that the arsonist's printing on the associate's blotter was in the same hand as the samples Brooks gave of his printing to Detective Marnie. The expert was briskly cross-examined about the difficulty of comparing printing as opposed to cursive handwriting and considered some differences between the samples and the incriminating note, but by and large he stuck to his opinion. None of the accused's fingerprints was found in the court, despite him having on his account handled a drinking glass, a plastic lunchbox, a refrigerator door, and gone through glass and polished timber doors. There was proof that O'Connor's boathouse had burnt down, and the Brooks admitted to being the culprit. The fire officers who found the annotated blotter were called, as were other officers who had fought and extinguished the fire. Bert Cowell was called to prove he owned the knife which stabbed the blotter to the associate's desk. And Monty was called to describe his movements during his watch. He said he let Ian Hanger and his friend out at 10 and locked the door. He carried out his inspections of the adjoining courts at midnight and again at about 2 a.m. He returned about 3, but said he was certain it was not later than 3. To the best of his knowledge, he locked the door and went to the watchman's restroom. About half an hour later, he heard a heavy thud and went to the main hall. He saw nothing and returned to his room. 10 minutes later, he heard a very heavy thud. This time, when he went to the hall, he saw smoke in the Ann Street wing. He tried to telephone the fire brigade from the bailiff's office, but the line was dead. He tried the phone in Justice Shee's chambers, but it too was dead. As he left the chambers, he saw Kristen out the front door. Now, I have a firm view that judges should not be criticised, but I'm bound to say that Justice Hoare appears to have been naive in accepting Monty's account. His Honour was particularly annoyed by the evidence that, on instructions, when the watchman left the Supreme Court to patrol the adjacent courts, the front door was to be left unlocked. He took up the point at the end of the Assistant Under Secretary's testimony. We have heard from a witness, the judge said, that it was the practice of the caretakers to leave the front door unlocked when they went on a tour of the Magistrates' Court. I do not know who's responsible in the Works Department for giving instructions, but it was obviously a very stupid instruction. You might see that someone in the department takes more interest in the security of the building. Justice Hoare appears to have thought that Brooks entered the building when Monty was out on his inspection. The evidence disproves that possibility. Monty should have left, and he said he did, to inspect the other courts at about 2, perhaps as late as 10 past. Inspection took half an hour, never more than 3/4. He would have been back and should have locked the door by 2:30, by 2:55 at the very latest. Brooks was moved on from the toilets a little after 3. Even if Brooks had entered during Monty's absence, Monty should have locked the door when he returned, but it was unlocked when Kristen arrived at 4. Angus Innes had unlocked it when he left at 1. Monty did not say he found the door unlocked when he went out at 2. Brooks did not say he had to unlock the door to get out. I have no doubt that Monty was asleep when Angus left and when Brooks entered and left, and the door remained unlocked after Angus left. The suggested instruction was so clearly silly that the evidence about it should have been doubted. The watchmen had keys and could easily have locked the doors when they went outside on their rounds. It makes no sense that they should be instructed to lock the door when they were in the building, but to leave it unlocked when they were absent. The evidence about the claimed instruction diverted attention from the fact that the door was unlocked after Monty said he had returned. The attack on the admissions came to nothing. The 2 detectives who were the principal recipients of the confession said that Brooks, though showing signs of having been drunk earlier, was sober and spoke coherently. A spirited criticism of the detectives for not writing up their notes of the lengthy conversations for some hours and then doing so together, possibly affecting the accuracy of the record, faltered because the defence was unable to suggest that Brooks had not said what was attributed to him. Judge not lest you be judged is an unusual rendition of the biblical passage which appears in the Gospels of St Matthew and St Luke. In both, according to the King James translation, the passage has a double negative: judge not and you shall not be judged. Brooks' early religious instruction had been from the King James Bible. Overwhelmingly, translations used in all churches employ the double negative. Alan Demack raised these facts in cross-examination and pointed out that it was improbable that an unlettered man like Brooks would know any rare or uncommon version of the Gospel passages. The implicit suggestion was that some other hand wrote on the blotter. In response, the prosecution called Roland Bush, the Presbyterian Professor of New Testament Studies at the University of Queensland. The point lost all its impact for the defence when it was realised that an editor of Penguin Publications had written his own translations, widely available in Penguin books, which had used the same expression as Brooks. Dr. Wilson, the government medical officer, examined Brooks on the day after his arrest. He noticed burnt hairs and reddened skin on the backs of both hands, fingers, wrists, and the left forearm. Brooks had told Inspector Buchanan that he scorched his hands when he putting paper on the fire. The Sheriff of Queensland was called to prove ownership of the Bible. the Chief Justice's tipstaff gave evidence that the Associate's desk in Court Number 1, the Civil Court, was neat and clean at close of business on Friday, 30 August. The cleaners gave evidence of what they kept in their cupboard. The Crown case closed at 11:45 a.m. on Wednesday, 27 November. Mr Gibney addressed for half an hour, Mr Demack for an hour. The judge summed up for 45 minutes. The jury took the same time to convict. Brooks was sentenced the next day to 6 years imprisonment. The judge recommended that he receive appropriate psychiatric treatment while in jail, remarking that it would be in Brooks' own interest to be kept in prison for a period long enough to recover from his addiction to alcohol. As to the circumstances of the offence, the judge said only that Brooks' irresponsible actions had caused enormous destruction and that society regards offences of this nature as very reprehensible. The remarks were surely an understatement and, in one respect, a misstatement. Indeed, the sentence appears, to me at least, an anticlimax, an inadequate response to the offence. The Supreme Court, as a building, was effectively destroyed. One wing containing the registry and one courtroom could be used temporarily on a makeshift basis. Many important historical records were lost forever. The essential work of the court was severely disrupted for a substantial time. Despite Brooks being a non-entity, his crime was motivated by malevolence towards society and the desire to strike at authority. The crime was not less serious because Brooks was a nobody. He was boastful in his disdain for what the court represented. The sentence does not appear adequately to reflect these considerations. Three factors might explain it. One is that Justice Hall was moderate in all his sentences. The second is that he characterised Brooks' actions as irresponsible when clearly they were malicious. The third is that he was very annoyed by the evidence that the building was left unlocked on departmental instructions. Blame shifted from Brooks to bureaucrats. Alan Demack observed that Brooks experienced a sense of exhilaration from his crime. Certainly one can detect in his assertions to the police that he was the arsonist a degree of boastfulness and an anxiety that he would not be given the credit for the crime. This misplaced swagger persisted. In 1971, Peter Nolan was a clerk employed by the public defender. His work took him frequently to the remand prisons, where he was well known by sight. On one of his visits, he was approached by a nondescript prisoner who said, "Mr. Nolan, I want you to know that I'm the man who burnt down the Supreme Court." John Hutton, now a magistrate, was in the late 1970s a solicitor employed by Elliott & Co. He was once consulted about a minor criminal charge and asked the client if he had any previous convictions. The reply was, "Yes, I'm the man who burnt down the Supreme Court." John asked Brooks why he had done it. The answer was that when he entered the hall, he saw the portraits in the gallery lit by moonlight. The judges appeared to be looking down at him, disapproving. He became disconcerted and angry. He said to himself, "How many men have you lot sent to jail?" and responded by deciding to burn down the court and the portraits with it. What I find most striking about the Supreme Court fire is the incongruity between the destruction of such an important building, symbol and seat of state judicial power, and the pettiness of the person and motive of the arsonist. He acted out of a ridiculous and unwarranted sense of self-righteousness. Brooks had no reason to feel aggrieved with the law. He'd only ever been arrested for public drunkenness, kept in the watchhouse for his own protection, and let go. There was at the time a widespread, profound disappointment that the destruction should have been the work of a man who was no more than a mean and spiteful drunk. History has many ironies. The fire, I think, is one of them.
Well, it's my privilege to move the vote of thanks to Richard. The lecture we've just heard, if I may say so, exhibited features of Richard's work with which many of us are very familiar: the clarity and precision of the language, the attention to the structure of the speech, which was complete, and he treated the topic with the seriousness it deserved, a seriousness which was emphasised by what we're also used to hearing from Richard, which is an appropriate dash of humour on the way through. But perhaps most importantly for this task, the time and effort that Richard has devoted to preparing his paper and to selecting and collecting his slides is something which we all should be grateful for. So may I ask you once again, please, to thank Richard in the usual way. And may I also present to Richard, as a token of our gratitude, the usual paltry gift. Now, I have some very brief announcements to make. First, I'm instructed to say that all Selden Society lectures are filmed and available on the Supreme Court Library's YouTube channel. So Richard now, perhaps not for the first time, will be a star of the screen. Secondly, two matters concerning the library. The Queensland Legal Yearbook of 2015 is now available, and also the library is conducting a very short online survey of users in order to try and improve its services by feedback. There are library staff here, you will see them in the foyer. If you're interested in either, please don't hesitate to approach them. And finally, and most importantly, you are all invited to enjoy refreshments in the foyer now. Thank you.